Labor Rights and Laws in Pakistan, by Mohammed Zahir, www.trcb.me/Zahir. Labor union or a trade union is a voluntary organization of workers formed to bargain collectively with management about wages and terms of employment, such as working hours, overtime, holidays, leaves, and other benefits. In case of a labor or industrial dispute, the most effective weapon that unions can use is to call a strike, which is walkout and work stoppage. On the other hand, if the management shuts down the workplace to pressure workers to accept its term, it is called a lockout. Labor rights. The Constitution of Pakistan contains a range of provisions with regards to labor rights found in Part 2, Fundamental Rights and Principles of Policy. Your article could be in this broadcast. Visit trcb.com to find out how. Article 11 of the Constitution prohibits all forms of slavery, forced labor and child labor. Article 17 provides for a fundamental right to exercise the freedom of association and the right to form unions. Article 18 proscribes the right of its citizens to enter upon any lawful profession or occupation and to conduct any lawful trade or business. Article 18 proscribes the right of its citizens to enter upon any lawful profession or occupation and to conduct any lawful trade or business. Article 25 lays down the right to equality before the law and prohibition of discrimination on the grounds of sex alone. And Article 37e makes provision for securing just and humane conditions of work, ensuring that children and women are not employed in vocations unsuited to their age or sex, and for maternity benefits for women in employment. Labor legislation. Pakistan labor laws trace their origination to legislation inherited from India at the time of partition of the Indo-Pak subcontinent. The laws have evolved through a continuous process of trial to meet the socio-economic conditions, state of industrial development, population and labor force explosion, growth of trade unions, level of literacy, government commitment to development and social welfare. To meet the above-named objectives, the government of Pakistan has introduced a number of labor policies since its independence to mirror the shifts in governance from martial law to democratic governance. Under the Constitution, labor is regarded as a concurrent subject, which means that it is the responsibility of both the federal and provincial governments. However, for the sake of uniformity, laws are enacted by the federal government, stipulating that provincial governments may make rules and regulations of their own according to the conditions prevailing in or for the specific requirements of the provinces. The total labor force of Pakistan is comprised of approximately 37.15 million people, with 47% within the agriculture sector, 10.50% in the manufacturing and mining sector and remaining 42.50% in various other professions. Every employer in an industrial or commercial establishment is required to issue a formal appointment letter at the time of employment of each worker. The obligatory contents of each labor contract, if written, are confined to the main terms and conditions of employment, namely nature and tenure of appointment, pay allowances and other fringe benefits admissible, terms and conditions of appointment. Termination of the contract. The services of a permanent worker cannot be terminated for any reason other than misconduct unless 1 month notice or wages in lieu thereof has been furnished by the employer or by the worker if he or she so chooses to leave his or her service. 1 month wages are calculated on the basis of the average wage earned during the last 3 months of service. Other categories of workers are not entitled to notice or pay in lieu of notice. All terminations of service in any form must be documented in writing stating the reasons for such an act. If a worker is aggrieved by an order of termination, he or she may proceed under Section 46 of the Industrial Relations Ordinance 2002, aimed at regulating the labor management relations in the country, and bring his or her grievance to the attention of his or her employer, in writing, either him or herself, through the shop steward or through his or her trade union within 3 months of the occurrence of the cause of action. Forms of termination have been described as removed, retrenched, discharged or dismissed from service. To safeguard against any colorful exercise of power, victimization or unfair labor practices, the labor courts have been given powers to examine and intervene to find out whether there has been a violation of the principles of natural justice and whether any action by the employer was bona fide or unjust. Labor Court Section 33 of the Industrial Relations Ordinance, 2002 permits any CBA or any employer to apply to the Labor Court for the enforcement of any right guaranteed or secured by law or any award or settlement. The provincial government derives its authority to establish as many labor courts as it considers necessary under Section 44 of the Ordinance. Each labor court is subject to jurisdictional limitations derived by its geographical parameters or with respect to the industry or the classes of cases allocated. Each labor court consists of one presiding officer appointed by the provincial government. The labor court adjudicates industrial disputes which have been referred to or brought before it, inquires into or adjudicates any matter relating to the implementation or violation of a settlement which is referred to it by the provincial government. All Pakistan Trade Union Congress APTUC, National Labour Federation NLF and National Trade Union Federation of Pakistan NTUFP said besides trade union organizations more than 60 political parties had been invited to participate in the seminar too. Visit trcb.com for more great articles like this now.